We're going to get there. So before I dive in here with our speakers, I do want to say this other final word, though, that with regards to artificial intelligence and intellectual property, what's been an interesting theme so far that I've heard a lot talked about as we've covered different topics over the past few days is the challenges of trying to understand what clear guidance you could give a company, what clear guidance that you as a practitioner could give to your clients. Some of that obviously changes depending on where you are around the world, but I do want to kick it off with this. Everything that is happening now with artificial intelligence in many ways is very global. From its very inception, if you think about people having to tag and label data sets then being able to be ingested into a machine. In many cases, to build a large language model and to tag data that goes into it to make it useful, that's been done in many different places around the world. There's obviously a lot of media attention on how those things are created, and whether it's having people who are working, in some cases for very low wages, to do very monotonous and rote work, to label a photo or image, and then put that into a database. It's kind of interesting because it shows from its very inception that to create what we now are starting to utilize in AI are things that are created all over the world and then put together. If you think about this though, on the other end, almost everyone in here has something to do with intellectual property. Many of us are from all these different countries around the world, and intellectual property in and of itself is not global. It's a national right. So if you think about it, you've got this interesting convergence, if you will, or you could call it a conflict, between intellectual property being national and each having divergent rights, to the fact that AI, to make it really work, it truly does have to be harmonized and international. Thank you. So that's a tension that we all have, and I think struggle with, and certainly don't have all the answers. At the same time, the laws that deal with intellectual property are very established, but we're now trying to have a different mindset when it comes to this new emerging technology. So without too much further ado, I've got a big presentation here that's been cut down. I'm not going to go into all this. I just want to hit one very brief thing before I turn this over to Laura to talk about copyright. But to give you a sense of how big of an issue this is, the group that I'm responsible for at Venable has done a study over the past couple of years and looked at a lot of data in terms of just what's happening around patent applications and filing. We studied in particular U.S. filings and got a lot of information and data here. And this is something that's actually been distilled from a couple articles that I and my team have written. But just to give you a sense of just how important this is, just over the past, let's say 2 years, November 21 to 23, and looking at search trends, we've seen a 367% increase in searches relevant to AI patenting. Why is that important? Obviously in the media, we get see it here, people talk a lot about it, but there still aren't a lot of good recent metrics to give you a sense of just how much effort and how much attention is being focused on trying to patent AI applications. And I find it quite interesting that you see that level of patenting, even though, just like you heard over the past 2 days, there's been a lot of discussion over, hey, I can't get software patents. Or in the US, I'm dealing with Alice rejections. It's really hard. I've got to jump a very high hurdle to be able to get a patent on some computer or software related thing. But despite that, you've got several companies, from big to small, several big ones, who are investing tremendous amounts in being able to patent AI-related applications. And as you know, obviously patent data is a lagging indicator. We find out, 18 months after you file an application, it gets published. So the data kind of trails. But it's interesting that you start looking back to see just how many companies, despite some of the hurdles, are really putting so much effort into this. The other thing I do want to put out is where we have had a chance to look at U.S. patent filing records, when we look at particular terms and what they cover, particularly those that focus on machine learning, looking since 2011, we found that it grew from 5,500 occurrences to over 100,000 occurrences, and I'm talking about occurrences of terms like machine learning from across different patent offices throughout the world. And that was by 2021. So you you can only imagine if you were to put that into a graph, what that sort of looks like. It's exponential growth. Last but not least, you see some quotes here from some of the different business magazines. These again are kind of trends that have been talked about here, but there's probably not a company out there today, maybe a few that are sort of resisting progress or fighting against technology, but the overwhelming majority of the companies, big to small, that each of one of you all probably represent or do business with, someone in the C-suite, someone at the executive level is really worried about and trying to figure out how does AI fit into their strategy. As we've talked about a lot here, IP and business really do go together as a strategy. I think, frankly, AI is just another layer to that. No different from when people got calculators to do better with math. Or when people who were artists, you put a nice camera in their hand and you can do art through photography. Just like 20, 30 years ago when the average person finally got a personal computer. Again, it helped productivity, but many of the laws, to the extent they had to be changed, were really just in terms of catching up with maybe the nomenclature, but the purposes, the values, and goals, and many times were the same. So with that, I'm going to pull out of this and turn to the copyright piece. Do you have slides? Okay. Let's see, let's see your assistant here.
It's okay. Thank you, Jacqueline, for the insightful introduction and information. Good morning, everyone. My name is Hawra. I'm IT specialist at Abunajara IT firm, Dubai. And I'm pleased to be with you today to share some thoughts about copyright and artificial intelligence. In fact, as artificial intelligence is capturing global attention with its impressive achievement and game-changing promises, it become and given the tight connection between innovation and IP, it become clearly plausible that IP be at the heart of legal discussion surrounding AI. So today we will be discussing different issues related to copyright and AI, examining the matter from dual perspectives. The first perspective is AI as a consumer of copyrighted data, and the other perspective is AI as a producer of copyrighted data. I will be building up on the previous presentation and try to add some other thought to it. Okay, so basically, let's begin with discussion copyright related to AI as a consumer of copyrighted work. In fact, in order for AI to learn and improve, they need to consume a huge amount of data. The problem is that when this data consisted of copyrighted work, and unless this use is licensed or there is an exception of copyright that is applicable, the use of copyright for training AI may infringe on the copyright associated with the data set attached, as well as the element of this data set enjoying separate copyright protection. And given that, as I said, that here we are talking about a large amount of data, securing license from numerous right holders is very challenging. And usually, typically, the much easier, the much convenient solution lie on leveraging existing copyright exceptions. Now, different countries have different set of rules. In fact, each country has its own set of copyright rules and exceptions. For example, some countries decided to introduce specific and explicit exception allowing AI training. This is the case, for example, of Article 3 and 4 of the EU Digital Single Market Directive. It's also the case of the Japanese copyright exception, which is deemed by a leading copyright scholar as the most open copyright exception available for AI use, and even they qualify it as a paradise for AI users. Now, in the US, leading copyright scholars argue that training using copyrighted material for the purpose of training AI model should be qualified as fair use. This is because they argue that this kind of use should be deemed as transformative and non-expressive use. Legal cases are emerging about the issue, as my colleague told. I gave the example of New York Times suing Microsoft and also OpenAI. And of course, with the outcome of this case and other similar cases, we'll have more clarity about this issue. Now, if we step back and look at this matter as a global landscape, we'll find that AI users are facing different difficulty when it comes to copyright. This difficulty range from the ambiguity of existing copyright exception in some jurisdictions. It also includes the limited scope of copyright exception in some other jurisdictions. And it becomes more complex when it comes to cross-border AI projects. Why? Because in this case, actors of this AI project will have to deal with many rules. And as I said before, this rule can be very ambiguous, this rule can be very limited, and also I need to stress again that here we are talking about a huge amount of data. So imagine, for example, that you have infringement. Imagine how, for example, the damages will be in case there is an infringement. So here we are talking about a big issue. And that's why it's important that lawmakers enact some kind of harmonized exception by signing relevant treaties. That kind of exception will help to bring legal certainty and also sufficient flexibility, allowing for more better development of AI technology. And if you know that basically, usually when we talk about international copyright law, the issue of limitation and exception is usually left to the discretion of each country and jurisdiction. But here, we need to have this harmonized. Why? Because there is no doubt about the profound application of AI technology and its game-changing application in all fields, military, health, education, tourism, social, everything. So, the more we give freedom for AI developer, the more we will have a better quality of AI, because the quality of AI is directly associated with the quality and comprehensiveness of input data. Also, in fact, this is also emphasized by many empirical studies that correlate and establish direct link between the degree of openness of AI exception and the level of economic and social welfare. And that means at the end that jurisdictions that have a clear and open copyright exception will allow for better development of AI innovation and reap the benefit of this technology. And this will be contrary to the other jurisdiction with ambiguous and limited exception. That's why this kind of harmonized global balanced exception is key to bridge the gap between different nations and also mitigate the gap between social and economic welfare, which will be resulting from the recent advancement of AI technology in many jurisdictions. Now, let's go to the other part of the story and discuss the copyright issue related to AI as a producer of copyright work. Okay? So, the main question is, does AI, specifically autonomous AI-generated output eligible for copyright protection? Here we need to go back and look to the notion of originality and creativity. In fact, in order to attract copyright protection, a work needs to be original and also creative. And if under a given the notion of originality and creativity is directly linked to human aspect. That means that autonomous AI-generated work, and by autonomous we mean that work that are generated in an independent way from human creation, or the human input is really limited and irrelevant. In this case, autonomous AI-generated work cannot enjoy protection. For example, in US, both the US Copyright Office and the US Court decided that only human being creation can enjoy copyright protection. And that means that autonomous AI-generated work cannot be eligible for copyright protection, and they are fall out the realm of copyright. In the EU, the notion of originality is also understood in the light of the European Court of Justice landmark decision that is linked to human beings expressing their free and creative choice. Now, the other requirement for copyrighted work to attract protection is to be generated by an identifiable one or multiple authors. In the scenario of AI, we can have many solutions. We can have no author, and thus the work will go to public domain, or we can have another option, which are inspired by the UK approach. In UK, the copyright law stipulates that in the case of computer-generated work, which lack human creator, the author will be deemed the person who made the necessary arrangement for the creation of the work. Here also, we have many options. This person can be simply the one who creates from the beginning the AI model, meaning the one who built and trained the AI model. This person can be the user who instructed the AI model to create a given output, especially when we are talking about a dynamic engagement between the AI model and the user, making the user making kind of creative choice and some kind of intellectual effort. Or simply we can have both and talk about joint authorship. Now, the other main issue that we need to consider when we talk about AI-generated output is the issue of infringement. Because when AI-generated output replicates a substantive part from the original copyrighted work, the upstream copyrighted work, the owner of this work can assert a copyright infringement claim. So, as you can see from this brief overview, that copyright is posing challenges for traditional legal copyright framework at both domestic and international level. And this makes it very essential for lawmakers to enact specific rule and have and discuss and sign adequate treaties to provide answer to this many hotly debated question, and shape the copyright law, the traditional copyright law, in such a way that copes with the challenges posed by this technology. So at the end of the day, the copyright can restore its expected and traditional role as an enabler of AI innovation, and not as an obstacle who will stifle this technology and deprive the humanity from the potential and promises of this technology. Of course, the future will bring many answers to our questions, so let's stay tuned and see you what next. Thank you for your time.
Hello everyone, my name is Manuel Giesen. I'm a Korean patent attorney from Berlin, in Germany. I will have a presentation about how artificial intelligence will help patent attorneys to draft patent applications. What is a typical way if you get an invention disclosure to filing a patent application? Normally it involves an inventor, patent attorney, and then some assistant staff. So the inventor is preparing some kind of invention disclosure, while the patent attorney is reviewing the invention disclosure and then conducting a prior art search either by himself or using some assistant staff. With the result of the prior art search, the patent attorney will prepare some kind of patent application. There will be other functions of other work done by the assistants, like proofreading or drawings or so on. Then there will be a final check by the inventor if the patent attorney has just understood the invention and or done everything correct. And finally, you can file the application. So this should be nothing new because this is how we work for ages. So, just going back to the single steps of the filing procedure or the presentation procedure, evaluation procedure. When it comes to point out the difference between the prior art and the invention, yeah, and then we go to the drafting of the claims based on the difference between the prior art. We draw some sketches to sufficiently disclose the invention, which is necessary in some jurisdictions, not in every, but in some. You will have to have a detailed description of at least one embodiment of the invention, and then you will do a final check. So, when it comes to pointing out the difference between the prior art and the invention here, we can use artificial intelligence search tools to identify and find documents way faster than we did in the past. I personally would not regard this as a perfect way because you have to supply very confidential information to a black box like the artificial search tool. But it can be very helpful, especially when you do invalidity searches or things like that. So we found out artificial intelligence is really helpful to point out the difference between two documents. So if you use prior art to just figure out, you find, for example, you find one document with the features A, B, and C. You find another prior art document with the features A, B, and D. And the invention discloses the features A, B, C, D, and E. So you know what to put your focus on. Yeah? Feature E is not known from prior art, and the attorney can finally focus on the differences and the technical fit of those differences to prepare a better patent application. There are artificial intelligent tools who can already draft a set of claims, and some of them are pretty good. It always depends on the quality of the information you put into the tool. Yeah? What I believe, or what I found out in some simple tests I did, artificial intelligent tools still stick pretty close to what kind of information you gave them. They do not generate any generic forms or abstracts, but yeah, you find some. You get a set of claims which is at least good enough to protect your one embodiment of your invention. And this might be enough this might be good enough for patent application of quite simple things. Yeah, like I found out it's like a toothbrush with a tank for the toothpaste, or things like that, where you have an automatic supply of toothpaste to the brush of it might also be good enough for some defensive publications, when it just gets to create prior art documents, when you're not really interested in the broadest scope of protection. And it's, of course, or it can be helpful with the dependent claims, just if you so providing the right information from the invention. What's good is the attorney is still needed, yeah, but the AI is catching up. So, say just from where we are now, there's human drafted patent claims can still be better than the ones drafted by artificial intelligence. But I would not say that we must be the same in 5 years, and in 5 years there might be a different view on the situation. Of course, artificial tools can generate specific pictures based on the given information, but I would rather prefer it the other way around. Yeah? You can tell an artificial tool to create a picture of a beautiful girl at the beach, so everyone has a different picture in his mind when I tell it. So, but if I give the picture to the artificial intelligence, it might be pretty easy for the artificial intelligence to describe the picture. So that's the way I would prefer to do it. It's like I already said, the quality of information and the drawings is very important for the quality of the description you get. It's and there might be difference in special technological fields. So I'm a mechanical engineer and mainly into innovations about hardware or hardware of electrical devices or so on. And there you have a very good, there you can have a very good disclosure of the invention by pictures. There are other technological fields like, might be in biotechnology or in chemistry or even in computer science, where the pictures do not disclose the invention that good, that you really get a detailed description of the idea just by the picture. And you still have problems to get generic concepts that go further than the picture itself. So if you want, you can not expect the artificial intelligence to create wider scopes than the information given within the invention disclosure. Yeah. As I said, it's pretty easy for an artificial intelligence tool to generate a description based on given sketches or drawings. It's all about the quality of the information, as I said. And the last point is, like, when I prepared this presentation, I was about that artificial intelligence is not yet able to point out technical effects and advantages of it. But I found out that there is, that this point is not true in every way. So there is already artificial, if you train an artificial intelligence tool, it is already able to point out technical effects and advantages. So, and it will be getting better and better in the next few years. So if you go from drawings to description, the artificial intelligence will help us a lot. And for the daily working business, of course, artificial intelligence can connect surveillance of the voice innovation with reference science or things like that. Yeah. And do some simple, easy checks, so you don't need that very algorithm for that is not to be very, very difficult at all. But I found out that it is like the difference in the language you draw. Yeah, some artificial tools are pretty good if you write an application in English. But if you use a different language like German or French or whatever, they have problems, or they are not that good in finding spelling mistakes, grammar risks, or so on, yet. Yeah. It's just a matter of training for the tools. But what it will help is to avoid office actions for formal issues, like there are some spelling mistakes in claim 1. Like I already get, I know some of that from the US Patent Office. Is like one of the offices who likes to remind you of formal issues, as well as the Japanese Patent Office. Others just like say, okay, please correct it, but sometimes you really get a problem with formal issues. So, as I said, spelling mistakes, grammar, check, that's easy, yeah. At the moment, just at the moment, yeah, it seems like human intelligence, like some secretary or whatever, is still better in finding incomplete sentences or missed out parts than artificial intelligence. But that's also just a matter of training, I suppose. The colors in the slide is just about the risky of it. So it's pretty easy for the tasks given in green, like the final check or doing the detailed description. And the other tasks are at least right now, at this point of time, still up to humans to draft a high quality patent application. So, where we are now, where are we now? So artificial intelligence is not yet able, so yeah, I would just stress the word not yet, to draft a high quality patent application on its own. So just giving an invention report with some pictures will not lead to a high quality patent application. So there's still some work to do for humans like us. But artificial intelligence will significantly change the way we draft patents and support us in the near future. What does it mean? If I can get my description for free, like I just give it to an artificial intelligence tool, get my description, I don't need like 20 hours for an application anymore, but I can shorten it to 10 hours. So I can draft 2 applications in the same time. I did with one in the past. So I have the option to do more business or focus on other topics, yeah, like the communication with the client and to understand the client's need and to support the client with his IP strategy and so on, or just understand the strategy of the client to provide the best possible solutions to the client. Thanks. I will hand over to our last speaker.
My name is Isam Abdul Tariq. I'm a legal consultant at United Trademark and Patent Services. Today I will not repeat the points which my colleagues already have already covered actually. So we will try to make it in brief. We don't want to take so long from your time as well. So we will just concentrate. Actually, I feel that the global practice is already being covered by our colleagues. So we will talk about the UAE also practice as well, so in order not to have a duplicate information. As you know, like artificial intelligence is a rapidly evolving field, raises the various intellectual property concerns. So there we will go to UAE, like under the federal law number 38 for the year 2021 on the copyright and its nobling rights in the UAE. The intellectual works are protected regardless of their description, form of expression, and significance or purpose. This means that the original works created by AI systems may be eligible for copyright protection despite their non-human nature. This is important to note that AI-generated works must meet also the criteria of the originality to qualify for copyright protection, just like any other creative works. Furthermore, the UAE has taken steps to strengthen its position as a hub for innovation by updating its IP laws. One notable change is in the UAE accession to Madrid Protocol and of the World Intellectual Property, the WIPO. This allows the international trademark application from member of the countries to be recognized up to 130 countries, as my colleague Ms. Mana also covered this point, facilitating the protection of AI-related trademark across the borders. This also will keep us under a challenge of to see the similarity or dissimilarity with the trademark in each jurisdiction as well, because some jurisdictions already started to use the AI, and you know that we have to be careful about the responsibility of using the AI. And for example, now the laws are being updated and enhanced to comply and tolerate the effect of the AI. But I feel that it is the responsibility of the person who is using AI actually while generating his invention for a patent or an industrial design or a trademark or a copyright. Why? Because AI does not have limits. Yeah, he has like, you know, it's an AI, it's artificial intelligence. Nobody knows how it thinks. It goes to many like machine learning and everything. So it's the person himself responsibility to check his work actually, to say that I did not copy any part of the invention of others or any parts of the trademark or like that. So we have to filter the work. I cannot say, no, I just throw the net and it gave me the fish from the market. No, it is we have to check whether this fish belongs to me or not. It should be only my fish, my idea, my invention should be. So AI is only like a machine where we can use it, but it should be in a proper way, because you know the ethics and values is really important in our IP work, because it should be like owned works actually. Okay, it is essential for individuals and business involved in AI to be aware of these intellectual property laws in the UAE in order to protect their rights, to avoid infringing on the rights of others. Consulting the legal experts specializing in intellectual property can provide a valuable guidance to ensure compliance with the relevant regulations. Moreover, the United Arab Emirates UAE recognize the importance of intellectual property in the context of artificial intelligence, as it continues to advance and play a significant role in the industries. Therefore, the UAE has established a legal framework to address the convergence of AI and IP. The copyright law already we have mentioned this point. Additionally, there is the UAE patent law, which will provide a protection of AI-related inventions. If an AI system produces an innovative and new invention, it may be eligible for patent protection. However, this is important to note: in order to be patentable, the invention must meet the criteria of novelty, inventive step, and industrial applicability as well. Furthermore, the UAE actively working towards enhancing the IP protection enforcement in the field of AI. The country has partnered with various international organizations to promote collaboration as a knowledge sharing in this area. This includes participating in initiatives such as World Intellectual Property Organization and engaging discussions about AI-related matters. Actually, we can talk about the AI algorithms are becoming capable of generating creative works such as music, literature, and art as well. This raises questions about the ownership of these AI-generated works. Currently, copyright law generated grants ownership to humans. But as AI systems becomes more sophisticated, there may be also debates on whether AI can be considered the author of honor, such as creators. And again, in the patent law, AI is being used as innovation process, including development of new inventions. This raises challenges for the patent law, as it becomes unclear whether an AI can be recognized as an inventor of a patent of application. And we cannot say the inventor name. It should be like a person, actually. Can we say that it's AI or not? Sometimes in the copyright, you can mention the hidden name of the author. Like you can say, like somebody who mentioned, let's say, a music compose, actually. You can cover his name. You can use the name of the knight. He's the composer. In the law even, it can be protected. But in the patent law, it's not there. You have to mention the human name, actually. So it is like, whether they can keep it in the future as the copyright law or not in the patent law, like to keep it as anonymous, actually. Current patent laws typically require an inventor to be a human being. So there may be some legal reform for to address this issue as well. In the trademark protection, AI technology can be used to infringe a trademark by generating counterfeit products or misleading the content. This makes it necessary to develop tools or techniques to detect a protection against AI-generated trademark violations. We have to take also about ethical considerations. This one also arises ethical questions. For example, AI algorithms may be used to infringe an IP rights by scrubbing copyrighted content or duplicating patent inventions. Addressing these ethical concerns requires a balanced approach to ensure that AI technology is used in a manner in respect of IP rights. And for example, this case actually it is a general case where actually we still new in this field for the AI, but even yesterday they announced there should be some AI council in Abu Dhabi, and it is headed by the VIP people in Abu Dhabi, so it will cover all these. I think yesterday they have announced it's a big council actually, and it's related to the security of the state as well. Because AI, it can be approaching all the secret information such as for the country, for name, numbers, health status of the people, genetics, everything. You can buy AI, you can, especially if any software is hacked, so you can get even the information from the banks as well. So it can make some problem in the litigation as well. So this one, like cyber security, should be really secure. That's why there is also some law for the securing this one. For example, also, there is, if we are using AI, there was litigation between the, everybody knows the Hammer car in America, it's well known, the Hammer car. Originally it was, I think, produced for the American Army. Now it can be used for individuals also in the market as commercial. The manufacturer of Hammer car, they found that it is used in some online video game. So where the car is being shot and it is turned over like that without any permission from the Hammer car. This can sometimes even it's giving like it's a strong car, but it can be also degrading the picture of the car. Because many kids, they will shoot the car, they will, you know, like overturn it like that. So the manufacturer of this one, they have sued the manufacturer of the online game, telling them that we did not give you any permission to use our model. This is, we have protected everywhere like that. So what was the allegation from the manufacturer? They said, no, we used AI to generate our online game. So this is a very weak excuse. You cannot keep the AI just stealing the models from the car, which is protected by them, and they paid already to protect them, and they say, no, this is the AI who uses it. It is not an excuse. Because you have a machine, which is AI, you have to control this machine on how to approach it. Because if I have laptop, I can breach the other people data. I can breach also banking, I can hack somebody, but I cannot say, no, it's the computer, not me. But who's directing the computer? In the end, I am computer. I am directing the AI how to do the games or this one. So there should be some ethical also and moral consideration while using the AI. This is very important actually, because as we said, it is like a machine. We are directing it where to go. So we can use it in a proper way. We can do it in an improper way. In a proper way, it means there should be some punishment for that. It should not be like only no, just to refuse the application. There should be some punishment for the person who used AI in an unethical also way. So overall, these are the most important points I want to cover. I don't want to take more time. These are the most crucial points which we want to cover. And if there is any questions, we are ready to receive. Thank you so much.
or comments?
Yes, I will come. Yes.
Do you need a microphone?
That's okay. Actually, talking about this ongoing matter about AI and the conflict, who will be the owner, who will be the creator, who will be... I have a question, and one idea came to my mind yesterday. We had an open discussion yesterday about the same issue. I don't know why we have to announce or declare that this work is created by AI from the beginning. Like, if your boss, for example, asks you to prepare one paper for him, one search, and you prepare it through AI, will you go and tell your boss that I prepared it through AI, or you will say that I am the one who prepared it? So I think the best thing now for the law is to announce and declare that the user is the creator. Because the AI machine will not create the work from itself. It will receive instruction from my side. I need a report about this or that. I need a story about this or that. I am the one who put the input. So the user should be the creator. And I don't know why I have to go and say that I prepared it through AI machine. I can say I am the inventor, I am the writer, I am the author. Because I am the one who gave the instructions or give the input to the machine to create the work. I don't know if you agree with me or not, but this is an ongoing conflict, and I don't know when it will be resolved. It started 3-4 years ago, and it's still going on, and no one knows when they will put some regulations to end it and to put some resolution. So some people say it's the developer, some people say it's the AI machine itself, some people say it's the user. So in my opinion, it should be the user.
Yeah, no, that's a great question. I think a few of us have some answers. I'll tell you on the issue, whether I agree with you or not, I think you're closer to the right answer. I have a slightly different answer, and I'll do it in twofold. I think the reason why we're still talking about it, quite honestly, is because all of the major governments around the world, even though they may be different, they all agree on this one thing. AI can't be the inventor when it's in patents, and AI can't be the creator if we're in the creative arts or copyright world. And that's written into most of the legislation or laws or regulations that most of the major jurisdictions follow around the world. There's obviously a lot of smart people dealing with that very issue that you're thinking of. And one thing that I've discussed a lot and done some talks with various governments about is how would you promulgate change without changing too much of how your law is. So an example of this in the US, there's already this concept when you talk about copyrights. It's very similar to what you're talking about. You create something, or something's created at your company, does that worker or employee, is his or her name actually listed as the copyright owner? No, by virtue of this concept called work for hire in copyright. The same concept could be extrapolated to patent law, and you could have invention for hire. Without, at least in the US, because I know the legislation here probably the best, you could actually make that kind of a change without having to make too much change definitionally to what's considered to be a patent and what's considered to be an inventor or not. It would be simply porting this same analogous doctrine over to the patent world, which would get you close to where you're talking about. I think the problem, though, also is a bit of philosophy as to like why you wouldn't want to have in every instance the computer being the owner, because I think still humans value human interaction and human ingenuity, and if you have something that is solely created by computer, you have this sort of existential question as to at what point did the creativity stop from the human, and was that all done by machine? But in situations where I think where we're going in the future and where we are now, that AI is no more different than you just using a new tool to create your goal. Just like you said, your boss comes and says, hey, get this done. Whether you use your computer, your phone, your pencil on a napkin, he doesn't care. Just get the job done. You give me the result. Again, you just used a different type of medium or tool. So I think that's kind of why there's that dissonance and difficulty around there. But I think you are right in terms of this should be a lot more simple. And I think we get to the simple by looking at what's already working that's analogous in IP laws around the world and making sure we can have similar logic applied from the copyright world to the patent world.
Yeah, I totally agree with you both, and I have discussed that this is one of the scenarios. But another aspect that we need to consider when discussing this debate is not only who contributed or what is the easier solution, also we need to go back to the very theoretical justification of copyright from the very beginning moment, why we created copyright. In the very beginning moment, we created copyright because we need to have more of this creation. So the way that we have more of this creation is by rewarding human creator. Now, when we talk about copyright and who will be the owner, we also need to have the same question. Which person we need to reward? Because here we need to reward, for example, the developer. Why? Because we need to have some incentive for the company who is creating this AI. So okay, we need to reward the user, as I said, for its creative choice when instructing the UI, the AI, especially when we are talking of some intellectual effort made during the dynamic engagement. But also we need to think about what is the purpose of rewarding and how this will reflect at the long term on the human well-being, how this will reflect at the long term on the improvement of this technology. So it's a multi-faceted debate that we need to consider every detail. So yeah, so
Actually, one
maybe
of
the solution can be in a 23 generous system that offers some kind of thin protection, something that is not copyright. Maybe you need to create something, for example, with short term of protection, something with thin protection, for example, only, for example, the act of exact copy will be deemed some kind of infringement. The whole matter is that we need to really listen to every point of view, and I think that it's also a matter that needs time because the more this technology become more developed, the more that new issue is created. And I think that's why it takes time for legislation. It takes time because it's not an easy. And one example I need to mention that for UK, for example, UK have a copyright exception for text and data mining, and then they decided that they want to make it more open. And then after many study and public consultation, they decided, no, we need to keep it as such and wait, because the answer is not easy. So that's right.
I think one of the effects that you're talking about is, I think in my opinion, people will become more lazy. And it will kill the creativity inside the human being. Instead of sit and read something and then, as you said, it's a mental work. It's a mental creation. So if AI is there for everything, even people are using it for their jobs. If I'm a journalist, I want a report about my visit to Dubai, attending IIPLA, I can go and just put some keywords and it will give me the report ready. Instead of me capturing everything and right from my side. So this is one of the side effects you're talking about. So the examination also of the work itself, one of our colleagues yesterday was talking about the verification of the work. Is it original? Who is the original author? Who is the original creator? Examination of the work itself should have some tools to differentiate between the natural human-based work and the AI-based work. This will give some kind of control over the creativity procedure. Thank you so much.
Thank you. Yes.
Yeah, just responding to that, and sort of maybe taking a sort of more positive spin, which is, yeah, I agree with some of the premise, which is, I like writing those notes. I can then really feel like I understood it, right? It's like I get to the end of it, good, I captured it all, like I get it, right? But I think there's AI systems out there in the future that are going to help us do that even better, right? And so hard to really articulate it more than that, but I do think that if you take the positive spin on it, there's going to be applications that sort of help us understand and think better and faster.
It will decide for your future. Where to go, where is you spend your vacation, give you some clues.
Yeah, maybe help me make better decisions. Yeah. Anyway, that was more just pure editorial, but yeah.
I have two questions. I don't have the answer for that, but it's just two thoughts about copyright. One thing about copyright is the lifetime of a copyright. It is 60 author's life in 60 years from there on, and AI can live perpetually. So what's the term of the copyright then? Second part, even if I do assign my copyright to a publisher or a music, whatever label or whatever it is, right? I do have certain moral rights over my copyright. If now you leave the moral rights up to an AI, what does it decide on? Where and how his work can be used, right? Because AI can be subject to biases, we know that. Now, will that be as good as human judgment? We don't know. So these are two human-related copyright issues which I feel like when we give away the right to an AI, the AI won't know how to handle these two things.
Yeah, those are good comments. I don't have total answers for those, but I'll say this, as a creative, it gives me two things to think of. So the term, at least I know for copyright in the US, is life of the author plus 70 years, so you're right, it's a long time. And there are different situations where either rights can revert back to that owner after even various corporate transactions. So one thing I can think, and I'm certain of this, whether it's whatever the latest trend may be, some sort of marrying up of an infrastructure with all of our rights, meaning IP. You talked about digital assets and rights, but I think that's one of those kinds of questions where you do see a need to take the IP on one side of the highway and match it up with the blockchain infrastructure on the other. And then that way, scope, license issues, if moral rights apply here but not there, can be tracked. You still have the asset, or still have the property, but there's different ways it could be utilized. And I think that will give you the ability in the future to have some better answers to that. I think on the other issue that was talked about before, between the conversation between the two gentlemen before, one thing I was going to add about where I think it's important too for entities, individuals, anybody who calls themselves a creator, this is from big companies down to a one person in a garage. I think in the future, as a result of what we see going on here today, it's become more important already, because I know of cases in China and various other places where I've been involved with some litigation, where if you can show evidentiary-wise the steps you've taken working with, let's say, a generative AI tool, to show that you were the creator, or that you were involved, I like to use this analogy, you were involved in this dance with the technology, and you can document it. That's the kind of thing that a judge, when you do have this issue of was this a human, was this computer, will this even qualify for protection or not? Companies, big companies, all the way down to individuals, if you have a discipline and a system to regularly document what you were doing, what was the scope of your input, what were your prompts to create whatever it is that you're now trying to assert, I think there's going to be far more importance put on it. So in the US, that's a nice simple way of saying litigation costs will go up.
Yeah.
And more discovery.
I have one point only. That's why. Thank you. So, hello? It's not working. Hello? No problem. Maybe you can. So you want to ask any
No,
more
it's
questions?
okay.
Hello. Yes. I have one. As we can talk about the legal point of view. Now we can say that AI is overlapping in all sectors of our life. Like, we can talk about health data, banking data, driving, and everything.
Now the government itself is starting using it.
Yes. So what we can do is, instead of changing the laws, because AI really is like a wave, it's coming everywhere. Instead of changing all the laws, which will be very costly, time-consuming, and also it's hectic for all the legislators actually. What I can do is, we can consider AI as like a machine which can be used like a laptop or a computer or a software actually, but it should not breach the data. Like in every country there is data privacy law right now. This is really a good example how we can follow this one. So we can use, as I can use my laptop to hack somebody's account or something, I can use also the AI how to breach his privacy for data or something, either it can be government or individuals. So what I can do is, we can make a law which organize the whole field of the AI, where you can use the AI just not to create something for you, because obviously the AI will go to the other people, patents, trademarks, copyrights, data, and he will copy from there. Even though some AI right now, like Wellbot or something, chatbot, they are sometimes mentioning from where he got this source. He will tell you one from this website, two from this website. Citations, yes. So it is something good, really. But sometimes you have to restructure it in your own way in order to make it different or distinguish from the real creator. This is number one. Number two, also, we have to filter each and every point from the AI, because it is my responsibility not to breach the other's data. So once it's breached, I have to be fined, I have to be jailed. If it is like, it depends on the outcome of the breach. Sometimes the breach will cost billions for some companies. And everybody knows, like in 2016, also in Aramco, Saudi Arabia, some data breach happened, and it cost about $2 billion actually. So now data privacy is something that we are not talking about only email hacked or something. We are talking about data privacy, about the future contracts, which is like the sales contract of oil or something, which cost billions also. So now we can see about like AI, it should be organized by a law which we can follow, same like data privacy law, that I can use the AI, but I am responsible of what AI is bringing to me. I have to filter each and everything, otherwise I will be responsible for
So
it.
you consider that assistant tool?
Yes.
As assistant?
As assistant tool, he can give you ideas. Like if I want to make a speech for my manager, this example. For example, my manager told me make a speech for me in the United Nations. Okay, I will make one speech with my legal manager, United Nations. AI will help me, but I will not take it as it is. I have to refilter it, to restructure it in order to make it distinguish. And I can take ideas only, not the full speech, copy paste like that. Otherwise, I will be responsible.
You have to put your human touch.
Yes, human touch will be there. This is I think the most important thing. Yeah. Right.
Is there another?
Yeah, I actually wanted to, it was a question, I just want to make a comment on this. I think the current copyright laws actually cover these aspects, because when it comes the difference between copyright and the patent, two different authors independently can come up with the work, and both of them can be copyrighted as long the same work, as long as they haven't collaborated, they weren't aware of the other person's work. So if AI can help one author to come up with something and make it copyright easily, and that AI technology available to other peoples, and other peoples could use it to come up with similar work, so just the value of your work using AI is going to diminish, because everybody can use the AI, because AI can help everybody coming up with certain work easily. Like, let's say somebody can just use a computer today versus like 20 or 30 years ago to just make a print and print out, like take a picture of his name, his face and print it. And if everybody could do that easily, so the value of that printing is going to come down if people want to copyright it. So the AI is going to make it more challenging for people to show that they come up with a creative way and get actually copyrighted work that is valuable. I just wanted to make that comment.
Yeah, good comment.
Okay, thank you.
I think it also means in the future, if you think about even patents and creativity, brought up a little bit yesterday, but I already see impacts that are probably going to build on the trend that we're already seeing. Again, to sort of piggyback off some of the discussion in the U.S. with the impact of Alice, the inability to get software patents, or at least it takes a lot of effort to get them. People certainly put a lot of money into it.
It's going to make it
That's gonna go
harder.
down.
It's going to make
Absolutely
it
right.
harder for people to show that they're qualified to get a patent,
That's right.
they are qualified to get a valuable copyrighted work,
That's right.
and
Yeah.
and beside that, I had another question which is not relevant to this one. I was just wondering if you have have you seen like Berne Convention, because you mentioned different copyrights in different countries in relation to AI, might be exception, might be issue, but Berne Convention has been around for since like 1886, and more countries are adopting that. And I'm wondering whether there have been any coordination related to AI in the countries that are part of Berne Convention.
Okay, if you look at Berne Convention, you will find that usually all the exceptions contained with the Berne Convention are not obligatory, are left to the discretion of the member. But there is one exception, which is the quotation exception. And okay, some scholars, some copyright scholars argue that the quotation exception in the Berne Convention act like kind of global framework. But again, the point that when we are talking about a harmonized solution, because as Justin said, here we are talking about a global matter when different boundaries in practice are not existent. That's why we don't need to have this boundary when we talk about enforcement or when we talk about protection. We need really to have harmonized exception. So if there is an exception contained within a convention, we need this exception not to be subject to the interpretation of a copyright scholar, something that is left to some court to decide or something like this. No, we need a clear-cut answer. We need some exception that is clear, some exception that bring legal certainty, some exception that is really balanced, designed in a balanced way, so it have a balance between different stakeholder interests. And that's why, yes, I agree with you. What we need to do is, especially within the WIPO, we need to have some kind of dialogue and see what version, what amendment we need to establish, what kind of additional clauses, additional protocol we need to sign to. We need to have this harmonized solution, which become more and more urgently pressing for the sake of development of AI, especially with the proliferation with cases and each stakeholder, like tech company, for example, take the case of New York against OpenAI and Microsoft. Each one is trying to lobby, each one is trying to put arguments, each one is trying to use the law on his side, but the benefit when that we have this dialogue within the WIPO that what is matter, it will be the humanity welfare and not the private stakeholder trying to impose that term.
Okay, thank you.
All right, I think we'll tie it up here. Thank you.
Thank you so much to our speakers for giving us the information and a thought-provoking to rethink about the convergence of AI and IP. What could be the possible side effects, the power of AI and the multiple views on the same is even it is positive, if it is biased and many more. So I hope you have enjoyed the session more than me, and I would like to inform you that our IP track is going to end now, very sadly. But the conference is still going on. I would request you to join the WLF session, that the litigation track that is still going on. So you can join the hall, that is Tabassul, I guess it is. So before that, I would request Dr. Hamida to join the stage in order to honor our speakers with the mementos. Please give it applause.